Well, coming back to one of our leading stories for this afternoon, for the second time this month, the National Energy Regulator, NERSA, and power utility Eskom will face off in court. Well, the issue is the money Eskom claims is owed by the public, and this has to do with under-recoveries that it couldn't collect through tariffs. Now, Eskom wants a nearly 17% hike, but ENC's business reporter Dimakatso Leshoro is in the North Gauteng High Court, and she joins us now from Pretoria. Dimakatso, a very warm good afternoon to you. Let's talk about this tug war, I suppose, including tariffs between Eskom and NERSA. What are some of the latest developments there?
So basically today is part B of the court case that, as you mentioned, started in early January. This has nothing to do, it's a bit of a separate case from that one. However, they are in a way interlinked because they're all about what Eskom says is entitled to get and what NERSA says, Eskom should be getting. Basically, today at issue is a 5.23% increase in tariffs that NERSA granted Eskom for the 2018-2019 financial year. Eskom is arguing this was wholly inadequate and they want more money. With me to give us more clarity, if you will, is the GM for regulation at Eskom, Asha Totalimaje. It's a very difficult surname, even for myself as a taller person. But just quickly take us through the issues here. They sound very complex because we have a lot of matters in between all of these. At issue today, you are arguing that you were entitled to get more than that 5.23%. Can you just take us through that?
Well, basically what we are, or our advocate is arguing, is that NERSA does not follow the regulations or the legislations that governs the way that it performs. And especially it refers to the Electricity Regulation Act. NERSA develops its own methodology, which is called the multi-year price determination methodology. And NERSA it's a very good, generally a very good methodology, but NERSA does not apply it. And what we also shown that NERSA had decided that it would change its original decisions, and that is what we are trying to share with the public and with the courts.
So obviously, one of the arguments that Advocate Chaskosson was making with regards to NERSA acting outside of its mandate was the fact that it's gone and changed the reasoning for those tariffs. Can you just take us through a bit of that? Because my understanding is that he's arguing that NERSA said something else, when it was granting those tariffs. Now in court, they're saying something different.
Yes, that is one of the reasons, is that NERSA produces a reasons for decision when it makes its decision, but in its court's papers it seems to have deviated from what its reasons for decision. But the fundamental issue is that NERSA did not apply its own methodology, nor did it apply the legislation that governs it, and that is our contention generally in this particular application.
But what NERSA said, when I spoke to the advocate earlier, he was saying basically, first of all, that you were not willing to go and have negotiate with them, go to the negotiating table. You just, they just saw court papers. So were you not open to a discussion, perhaps prior to coming to a public forum like this?
That is completely untrue. Obviously, the advocates were not up to speed. We had a discussion on the 6th of June with all the leadership of between Eskom at that time and NERSA at that time. And NERSA agreed with us wholeheartedly. The legal department was represented there, that this is the only way that NERSA's decision can be reviewed. So what is being proposed is obviously a backfoot again, and it is not true.
Just finally, I'm sure we're out of time now. How big an issue, or rather a stake, did this play in the load shedding that we saw? Because we understand that obviously if you don't have enough revenue, that possibly could impact what you can do.
Yes, it is very difficult to make that kind of a decision, but obviously they are interlinks in the sense that when NERSA has, or Eskom has limited funds, it has to prioritize its decisions. It is likely that some of the maintenance or build decisions had to be reprioritized and did not happen. But I would not want to make a complete direct link with that.
As you heard, these issues are quite complex. I mean, this is not the only court case. There are further court cases that are coming on. This particular one is set for 3 days. So we'll hear, I think, Mr. Chaskalson will conclude his, arguments today, we hope. But the matter is set for 3 days, and then we'll hear from NERSA's side. But, there is another case that is coming that's also part of, related in a way to this. So quite complex issues, but we'll keep you up to speed. Back to studio.